Dr. David Clark.
Yeah. Labour will be supporting this bill, and I thank the Minister for his contribution. There have been many ministers who have contributed to this over the years, and I think I'm right in saying it dates back to its introduction dates back to the time of the Honourable Judith Tizard in this House. It's been around a wee while. It's made steady progress, and now we are here debating the final form, but with more SOPs on the way. So it's a journey. It is indeed a journey, and we support it because when we look at the purposes, Mr. Chair, its most fundamental. Part 1 covers the purposes of this Act, and it says that the purpose of this Act is to provide an efficient and effective patent system that promotes innovation and economic growth while providing an appropriate balance between the interests of inventors and patent owners and the interests of society as a whole. And so often when we debate these intellectual property issues, we come back to the question about how the interests of society as a whole are protected. And, you know, the debates around software, patenting and innovation in that sphere often revolve around whether the interests of society as a whole are served by protecting inventors to an extent that may be beyond what is necessary to encourage innovation in that sector. There are plenty of people who say that innovation is rife in many sectors and that very little patenting or intellectual property protection is required. And other sectors, when we think through to pharmaceuticals, require a huge amount of investment when it comes to intellectual property, and the billions of dollars that go into drugs that are of benefit to society as a whole simply would not be invested without appropriate protection in place. And that is why this kind of law, intellectual property law, needs to find the right balance between the interests of the inventors, what the incentives need to be to ensure that they do invest in stuff that is good for society as a whole, and the benefit that accrues to society, and whether it would be more or less depending on the incentives that are put in place. And we could question some of the things that are being debated in the leaked TPPA the negotiations, and whether, and the issue always comes back to, Mr. Chair, whether the interests of society as a whole are being served by the changes that are proposed. And the one that's in the public domain most often is the extension of Disneyland's intellectual property protections, and whether that is actually of use to society as a whole, given that no new creative content is likely to arise from historic material. So this bill itself, my colleague says that, I don't know if I heard her correctly, that that's a Mickey Mouse proposition, but if not, I'm extrapolating, and there may be some truth in that. Of course, we don't know what the final shape of those arrangements will be, and we're not privy to the negotiations, and that is, of course, something New Zealanders are concerned about, because we all want not only the interests of society as a whole, but our national interests to be taken care of. And Mr. Lotoinga, I'm sure, would agree with me if he had the opportunity to speak on this matter. Mr. Chair, Part 1 covers those purposes, the preliminary purposes that I mentioned, striking that balance. It also mentions in the opening gambit there about New Zealand's international obligations, and the TRIPS it springs to mind for me, those agreements in terms of the WTO, expectations, what serves to make sure that international trade is looked out for, that we all as countries are encouraged to create new intellectual property, and that is good for society as a whole, broader than just national boundaries. So these purposes in the Act look at the criteria for granting a patent. They provide for procedures that allow the validity of a patent to be tested, and they provide certainty for those patent owners and users of patent interventions. And they address some Māori concerns relating to the granting of patents for inventions derived from indigenous plants, and of course Waitu 262 is something that many members of this Parliament will be familiar with from the debates over the years. That's something that is not finally settled and which I personally believe needs the attention of government, and the failure of this government to progress that matter fully is also a concern and should be a concern for this House, Mr Chair. Mr Chair, when we go... Mr Chairman. Mr Chair, when we look further into Part 1, we see that it covers the meaning of novel, which of course is a simple and basic requirement of outlining what a patent is. My colleague Mr Mallard says he's read the book. He's read the book on what novel is about. The meaning of an inventive step, so what it actually means to invent something new, because of course, you know, if that's not defined correctly, we can have people who are trying to claim that they have rights to something that again does not benefit society as a whole, if it's something that already exists, if it's something from which we already derive benefit, and then somebody is seeking a private rent, is seeking to make profit from something that does not belong to their own intellectual property contribution, and that then is a net drain on society as a whole. And so it's important that we lay out exactly what each of these things are. It also covers the meaning of a prior art base, and I'd ask the Minister and the Chair to clarify that, as I haven't been particularly engaged in that discussion about prior art base, and I think the House would be interested to know exactly what that looks like in practice. What does it mean in those clauses which describe the prior art base? And then, of course, disclosures and the meaning of useful, because we're talking here, come back to those first principles, about what is useful for society as a whole. So, Mr Chair, as I said from the outset, Labour will be supporting this legislation. New Zealand's existing patent law, in our view, is too generous to those people seeking patents. Too many corporations get monopoly rights, and many are multinational corporations that can get patent rights to investors inside New Zealand that would not be protected overseas. We're pleased to see that this is being upgraded. It's happened over a long period of time, being introduced first in 2008, as I said, by the Honourable Judith Tizard, and still being debated actively today. But it is great to see the bipartisan nature of the debate here in the Parliament. So I won't speak for much longer, Mr Chair. I'm simply interested, though, in hearing from the Minister further about the artful, the meaning of a prior art base, that the House could understand that a little better, and for my own ignorance in that matter, that I might have that clarified by the Minister. So thank you very much, Mr Chair.
Gareth Hughes.
Chair, ngā mihi nui kia koutou, kia ora. It's a privilege to rise and speak in the committee stage.